Hello everyone, welcome to Let's Crack UPSC CSE English. In our crash course for UPSC CSE 2021 preliminary examination Inspire. So today we'll see the Supreme Court, one of the important topic in Indian polity. Before that, it's my pleasure to welcome you all on Unacademy, India's largest learning platform, where you will get daily live classes, structured courses, unlimited classes, and live tests. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy and you can also join our Telegram group using this link. Yes, friends, here is the mega subscription offer valid till 20th April. So friends, if you will opt for our subscription for 1 year, you will get validity till Prelims 2022, and those aspirants will subscribe the course for 2 years, they will get validity till Prelims 2023. Yes friends, so do not miss the opportunity to grab extra subscription. Yes, additional subscription on your duration of 1 year and 2 year plan. Yes friends, those aspirants are planning to start their preparation with our paid courses. We have plus and iconic courses where you will get 10% discount after using referral code RBI Live. Yes friends, for optional subscription as well, you can use this referral code and get 10% discount. Yes, this is the combo subscription available for general studies and optional. Yes, we have 1 year, 2 year and 3 year subscription. So 10% discount is applicable on this course as well. Yes friends, here you'll get 10% discount after using referral code RBI Live. Yes, those aspirants are preparing their graduations, means they are pursuing their graduations, or those who are planning to start their preparation after their 12th examination, they can opt for our iconic subscription. Yes, where those aspirants will eligible to get all the features of plus courses along with iconic courses, where in iconic course extra features like personal guidance, experts guidelines, study planner and material, and test analysis. Yes, which will help you throughout the preparation. Yes, congratulations to all aspirants who have cracked UPSC Civil Services Main Examination 2020. Yes, all those eligible aspirants will get free comprehensive interview guidance program from Unacademy. Yes, in this our comprehensive guidance program for interview, our panelists and mentors will guide them for the preparation of interview. Yes, where we will conduct DAF analysis, mock interviews by experts, and flexible schedule. Yes. So friends, those aspirants are planning to appear for interview in next year, that is 2022. They must qualify for prelim and mains examination. So here is the opportunity to evaluate your preparation through our free test series. Yes. Yes. Hello Murli. Hello Ram Kumar. In today's lecture, we'll see Supreme Court. Yes. So in this free test series, you will cover your complete current affairs part and general studies. Just you have to use code RBI Live to unlock these tests. Yes, this is our new batches for UPSC CSE, like 1 year batch, 2 year batches, and NCRT targeted batches. Yes, do not forget to enroll yourself for Unacademy Combat with, with code RBI Live. Yes, we are conducting this combat, that is free scholarship test, on every Sunday at 11 a.m. Yes, in the morning 11 o'clock, and this is available in both medium, English medium and Hindi medium. So we'll start today's topic. Supreme Court. Yes, friends. See the historical building of our Supreme Court. Yes. So our Indian Constitution has established an integrated judicial system. Yes. This is the feature of our judicial system, that is integrated, where the Supreme Court at the top and the high courts below it. Yes, under high court there is hierarchy of subordinate courts, that is district courts and other lower courts. Yes, we have integrated judicial system. So friends, see the pyramid. So at the apex level we have Supreme Court, then High Court at the state level, and below that low courts and subordinate courts. Yes, so integrated judicial system we have. Yes, so Article 124, Article 124 to 147 in part 5 of the Constitution deals with the Supreme Court's organization, independence, jurisdiction, powers, procedures. Yes. So our Articles 124 to 147 deals with the organization, independence, jurisdiction, powers and procedures of the Supreme Court. Yes, the Supreme Court of India is the country's highest judicial court, and it is the final court of appeal in the country. Yes, the Supreme Court of India is the highest judicial court in our country, and it is the final court of appeal in the country. Yes, this is the final appellate court in the country. Now we'll proceed with the brief history of Supreme Court. Yes, the promulgation of Regulating Act 1773, which established the Supreme Court of Judicature at Calcutta as a court of record. Yes, the promulgation of Regulating Act 1773. Yes, which establishes the Supreme Court of Judicature at Calcutta as a court of record with full power and authority. Yes, it was established to hear and determine all complaints for any crimes, and also entertain, hear and determine any suits action in Bengal, Bihar and Odisha. Yes. So the Supreme Courts at Madras and Bombay were established by King George III in 1800 and 1823 respectively. Yes, the Supreme Court of Madras, which was established in 1800, and the Supreme Court of Bombay was established in 1823. Yes. So the India High Courts Act 1861. Remember guys, the historical meanings of our judicial system, where India High Courts Act 1861 created high courts for various provinces and abolished Supreme Courts at Calcutta, Madras, Bombay, and also Sadar Adalats in presidency towns. Yes. So the High Courts Act 1861 was created high courts for various provinces and abolished Supreme Courts at Calcutta, Madras and Bombay. Yes, and also the Sadar Adalats in presidency towns. Yes. So these high courts had the distinction of being the highest courts for all cases till the creation of Federal Code of India under the Government of India Act 1935. Yes. After the India High Courts Act 1861. Yes. After the creation of India High Courts Act 1861, where the abolition of Supreme Courts at Calcutta, Madras, Bombay, and Sadar Adalats in presidency towns. Yes. So these high courts had the distinction of being the highest courts till the new act, that is Government of India Act 1935, came to exist. Yes, in this act, Government of India Act 1935 was discussed about or was mentioned Federal Code of India. Yes. So the federal court had jurisdiction to solve disputes between provinces and federal states and hear appeal against judgments from high courts. Yes. So after India attained independence in 1947, the Constitution of India came into being on 26 January 1950. Yes. The Supreme Court of India also came into existence and its first sitting was held on 20th January 1950. Yes, 2 days later. So the Supreme Court of India also came into existence and its first sitting was held on 20th January 1950. Yes. So before 1950, the British Privy Council had the jurisdiction to hear appeals from India. Yes, before 1950, British Privy Council had the jurisdiction to hear appeals from India. So the law declared by the Supreme Court. Now, the law declared by the Supreme Court is binding on all courts within the territory of India. Yes. So it has the power of judicial review. So to strike down the legislative and executive action contrary to the provisions and the scheme of the Constitution. Yes, the distribution of power between union and states or inimical to the fundamental rights guaranteed by the Constitution. Yes. So, Supreme Court has the power of judicial review, which used to strike down the legislative and executive action contrary to the provisions and the scheme of the Constitution. Yes, as we have seen number of cases of judicial review in past few years. Now, after that we'll see the constitutional provisions of Supreme Court. Yes, so the Indian Constitution provides for a provision of Supreme Court under Part 5, that is the Union, and Chapter 6. Part 5, Chapter 6. Yes, the Union Judicial. So Article 124 to 147 in Part 5 of the Constitution, which deals with Supreme Court. Yes, as we have discussed. So The Indian Constitution under Article 124 Clause 1 states that there shall be a Supreme Court of India constituting of a Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges. Yes. So, the Indian Constitution under Article 124 Clause 1 states that there shall be a Supreme Court of India constituting of a Chief Justice of India. Yes, and until Parliament by law prescribing a larger number, not more than 7 other judges. Yes, this was old provision. Now in this lecture itself, we'll see updated provision in this regard. Now just remember that the role of Chief Justice of India, CJI. Now the jurisdiction of the Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction, and advisory jurisdiction. However, there are more multiple powers of the Supreme Court. Yes. So, in terms of jurisdiction of the Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction, and advisory jurisdiction. Yes. Now we'll see the composition and appointment. Yes. At present, the Supreme Court consists of 31 judges, 1 Chief Justice, and 30 other judges. Yes. So the Supreme Court of India presently consisting 31 judges, where 1 Chief Justice of India and 30 other judges. Yes. So, Supreme Court number of judges bill 2019 has added 4 judges to strength. So, it increased the judicial strength from 31 to 34, including the CJI. Yes. Now, Supreme Court Bill of 2019 has been or has added 4 judges to strength. That is, now strength of the Supreme Court was increased from 31 to 34. Yes, which includes Chief Justice of India. Now originally the strength of the Supreme Court was fixed at 8. Yes. So earlier the strength of the Supreme Court was fixed at 8, that is 1 Chief Justice and 7 other judges. Yes, as we have discussed earlier. So now in the recent bill, that is Supreme Court Bill of 2019, which increased or added 4 judges. So now its strength is 34 judges, including Chief Justice of India. So the Parliament is authorized to regulate them from time to time. Yes. Now, the Constitution declares Delhi as the seat of the Supreme Court, and it also authorizes the Chief Justice of India to appoint other places as a seat of the Supreme Court. Yes. So, if we are talking about seat of the Supreme Court, so the Constitution declares Delhi as the seat of the Supreme Court. Yes, but it also authorizes the Chief Justice of India to appoint other places as a seat of the Supreme Court. Now, he can take decision in this regard only with the approval of the President. Yes, he can take decision in this regard, that is Chief Justice of India, only with the approval of the President, and this provision is only optional, not compulsory. So this means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as the seat of the Supreme Court. Yes. Now, appointment of judges. Yes, friends. After that, we'll see the appointment of judges. So, yes, Murli. See, originally, just clear that. Now, initially, when our constitution enacted, that time the strength was total 8, which is including Chief Justice of India, which means one Chief Justice of India and 7 other judges. Now, after that, what happened? Time to time, Parliament increased the strength. Now, still that process of adding judges, now bill is passed, but not yet 4 judges added. So currently we have 31 judges only. Now, after the procedure, the bill was passed recently in 2020. Yes, the Supreme Court number of judges bill of 2019. Yes. See, this is the current strength, and as per the bill, now definitely upcoming in coming days will see the 35 number of judges total 35. Yes. Yes, Murli. Yes. If is there any addition into that, definitely I'll share with you in the next lecture. But as per my knowledge, this is the current strength of the Supreme Court judges. Yes, now we'll see the appointment of judges. Yes. So, the judges of the Supreme Court are appointed by the President. Yes, the judges of the Supreme Court are appointed by the President of India. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. Yes. Yes. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Court as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of judge other than Chief Justice. Yes. So, the appointment of judges, the judges of the Supreme Court are appointed by the President and the Chief Justice is appointed by the President after consultation with the such judges of the Supreme Court and High Courts as he deems necessary. And the consultation with the Chief Justice is obligatory in the case of appointment of judge other than Chief Justice. Yes, now the appointment of Chief Justice from 1950 to 1973, the practice has been to appoint the senior most judge of the Supreme Court, yes, as the Chief Justice of India. Appointment of Chief Justice from 1950 to 1973, the practice has been to appoint the senior most judge of the Supreme Court as the Chief Justice of India. So, the established convention was violated in 1973. Yes, if we are talking about the general, yes, the general convention, that is appointment of Chief Justice among the judges of the Supreme Court, which means the senior most judge of the Supreme Court is appointed as the Chief Justice of India. So this established convention was violated in 1973 when A.N. Roy was appointed as the Chief Justice of India by superseding three senior judges. So again in 1977, M.U. Beg was appointed the Chief Justice of India by superseding the senior most judge. Yes. So this discretion of the government was curtailed by the Supreme Court. Yes, the discretion of the government was curtailed by the Supreme Court in the second judge's case 1993, in which the Supreme Court ruled that the senior most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Yes. So there was violation of the established convention of appointment of Chief Justice in 1973 and 77. So in 1993, the discretion of the government was curtailed by the Supreme Court under second judge's case 1993, in which Supreme Court ruled that the senior most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Yes. Now we'll see the collegium system. Yes. Collegium system. So collegium system was born through three judges case. Yes. And it is in practice since 1998. So it is used for appointments and transfers of judges in high courts and supreme courts. So collegium system was born to three judges case. Yes. So there is no mention of the collegium either in the original constitution of India or in successive amendments. Yes. Now we'll see the working of collegium system and NJSE. Yes, the collegium recommends of the names of lawyers or judges to the central government. Similarly, the central government also sent some of its proposed names to the collegium. So, collegium considers the names or suggestions made by the central government and resends the file to the government for final approval. So, if the collegium resend the same name again, then the government has to give its assent to the names. But time limit is not fixed to reply. So this is the reason that appointment of judges takes a long time. Yes. Now, to the 99th, yes, the 99th Constitutional Amendment Act 2014, the National Judicial Commission Act NJSC was established to replace the collegium system for the appointment of judges. Yes, the 99th Constitutional Amendment Act 2014, the National Judicial Commission Act NJSC was established to replace the collegium system for the appointment of judges. So, however, the Supreme Court upheld the collegium system and struck down the NJSC as unconstitutional on the grounds that the involvement of political executive in judicial appointment was against the principle of basic structure, that is the independence of judiciary. Yes. So the Supreme Court upheld the collegium system and struck down the NJSC as constitutional on the grounds that the involvement of political executive in judicial appointment was against the principle of basic structure, that is independence of judiciary. Now, controversy over consultation and evolution of collegium system. Yes, the Supreme Court has given different interpretations of the word consultation. Yes, in the above mentioned provisions. In the first judge's case, 1982, the Supreme Court held that consultation does not mean concurrence and it only implies exchange of views. Yes, in the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. Yes, now, if the second judge's case, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Yes. Then the third judge's case, 1998, the court opinion that the consultation process to be adopted by the Chief Justice of India, which requires consultation of plurality judges. Yes, consultation of plurality judges. Now, the sole opinion of the Chief Justice of India does not constitute the consultation process, and he should not, or yes, the sole opinion of the Chief Justice of India does not constitute the consultation process, and he should consult a collegium of four senior most judges of the Supreme Court, and even if two judges given an adverse opinion. Yes. Now, the court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Yes. Yes, now qualification, oath, and salaries. So, a person to be appointed as a judge of the Supreme Court should have the following qualifications. Yes, he should be a citizen of India. He should have been a judge of a high court or high courts in succession for 5 years. He should have been an advocate of high court or high courts in succession for, yes, he should have been an advocate of a high court for 10 years. Yes, he should be a distinguished jurist in the opinion of the president. Yes. So, if we are talking about the qualifications, that is, he should be a citizen of India. He should have been a judge of a high court for 5 years. He should have been an advocate. He should have been an advocate of a high court for 10 years. And he should be a distinguished jurist in the opinion of the president. Yes. Now, the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Yes. Oath and affirmation. So, a person appointed as a judge of the Supreme Court before entering upon his office has to make and subscribe to an oath or affirmation before the president, or some other person appointed by him. Yes, for this purpose, in the oath, a judge of Supreme Court swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to the best of his ability, knowledge, and judgment to perform the duties of the office without fear or favor, affection, or ill will. Yes, to uphold the Constitution and the laws. Yes. Then we see the salaries and allowances. Yes, the salaries and allowances, privileges, leave, and pension of the judges of the Supreme Court are determined from time to time by the Parliament. Yes, they cannot be varied to their disadvantage after their appointment except during a financial emergency. Yes, in 2018, the salary of the Chief Justice was increased from 1 lakh to 2.80 lakh. Yes, 2.80 lakh per month, and that of a judge from 90,000 to 2.50 lakh per month. Yes, so in 1950, the salaries were fixed at rupees 5,000 per month and 4,000 per month respectively. In 1986, their salary were raised to rupees 10,000 per month and 9,000 per month. Yes, in 1998, the salaries were raised to 33,000 per month and 30,000 per month. In 2009, their salary were raised to 1 lakh to 90,000 per month, and now currently, recently in 2018, the salary of the Chief Justice was increased from 1 lakh to 2.80 lakh per month, and that of a judge from 90,000 to 2.50 lakh per month. Yes, they are also paid statutory allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. Yes, the retired Chief Justice and judges are entitled to 50% of their last withdrawn salary as monthly pension. Yes. Tenure of judges. So, the Constitution has not fixed the tenure of a judge of the Supreme Court, but it makes the following three provisions in this regard. Yes, yes. So, the Constitution of India has not fixed the tenure of the judge of the Supreme Court, but there are few provisions in this regard, like he holds office until he attains the age of 65 years. Yes, any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. He can resign his office by writing to the President. He can be removed from his office by the President on the recommendation of the Parliament. Yes, removal of judges. Now we'll see the removal of judges. See, a judge of the Supreme Court can be removed from his office by an order of the President. Yes, the President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. Yes, the address must be supported by a special majority of each House of Parliament, that is, a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. Yes, the grounds of removal are two, like proved misbehavior or incapacity. Now, the Judges Inquiry Act 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. So, no judge of the Supreme Court has been impeached so far. So, impeachment motion of Justice V. Ramaswamy 1993 and Justice Deepak Mishra 2017 to 18 were defeated in the Parliament. Yes. Now we'll see the present Chief Justice of India, Honorable the Chief Justice of India, Honorable Mr. Justice Sharad Arvind Bobde. Yes, the Chief Justice of India. Yes, this is the information regarding him. Yes, he sworn in as Chief Justice of India on 18th November 2019 and due to retire on 23rd April 2021, that is in this month. Yes. So, the Chief Justice of India, Mr. Sharad Arvind Bobde, yes, he was born at Nagpur in Maharashtra. Yes. So, practiced law at Nagpur bench of the Bombay High Court with appearances at Bombay before the principal seat and before the Honorable Supreme Court of India for over 21 years. Yes, designated as senior advocate in 1998. Yes. So, earlier he was Chief Justice of Madhya Pradesh High Court in 2012 and then in 2013 elevated as a judge of Supreme Court of India. Yes. Now friends, just have a look on the list of former Chief Justice of India. Yes. Mr. Justice Harilal Jakisundas Kania was the first Chief Justice of India. Yes. Then Mr. Justice M. Patanjali Sastri. Then Mr. Justice Mahechand Mahajan. Mr. Justice Bipin Kumar Mukherjee. Yes, Mr. Justice Sudhir Ranjan Das, appointed as the CJ of India on 1st February 1956. Then Mr. Justice Bhuvaneshwar Prasad Sinha, Mr. Justice P.B. Gajendra Gadkar, Mr. Justice A.K. Sarkar, yes, Mr. Justice K. Subbarao in 1966, Mr. Justice K.N. Wanchu in 1967, Mr. Justice M. Hidayatullah in 1968, Mr. Justice J.C. Shah 1970, Mr. Justice S.M. Sikri 1971, yes, Mr. Justice N. Ray 1973, Mr. Justice M. Hamidullah Beg 1977, then Mr. Justice Y.V. Chandrachud in 1978, Mr. Justice P.N. Bhagwati 1985, then Mr. Justice R.S. Pathak 1986, Mr. Justice E.S. Venkatramaya 1989, Mr. Justice Sabachi Mukherjee 1989, yes, then Mr. Justice Raghunath Mishra 1990, Justice K.N. Singh is also appointed as Chief Justice of India in 1991, then Honorable Mr. M.H. Kania appointed the Chief Justice of India in 1991, then Mr. Justice L.M. Sharma 1992, Mr. Justice M.N. Venkatchalaya in 1993, Mr. Justice A.M. Ahmadi 1994, Mr. Justice J.S. Verma 1997, Mr. Justice M.M. Panchi in 1998, then Dr. Justice A.S. Anand 1998, Mr. Justice S.P. Bharucha 2001, Mr. Justice B.N. Kripal appointed as the Chief Justice of India in 2002, then Mr. Justice G.B. Patnaik appointed as a CJI in 2002, then Mr. Justice V.N. Khare in 2002, Mr. Justice S. Rajendra Babu in 2004, Mr. Justice R.C. Lahoti 2004, Mr. Justice Y.K. Sabharwal 2005, Mr. Justice K.G. Balakrishnan 2007, Mr. Justice S.H. Kapadia 2010, Mr. Justice Altamas Kabir 2012, Mr. Justice P. Satvasivam 2013, Mr. Justice R.M. Lodha 2014, then Mr. Justice T.S. Thakur 2015, yes, then Mr. Justice Jagdish Singh Kehar 2017, then Mr. Justice Deepak Mishra 2017, and then Mr. Justice Ranjan Gogoi in 2018, yes. Yes, this is the former Chief Justices of India. Now we'll see the acting, ad hoc and retired judges. Yes, friends. So, First is acting Chief Justice. So, the President can appoint a judge of the Supreme Court as an acting Chief Justice of India when the office of Chief Justice of India is vacant. Yes, the Chief Justice of India is temporarily absent. The Chief Justice of India is unable to perform the duties of his office. The next, ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. Yes, he can do so only after consultation with the Chief Justice of the High Court consent and with the previous consent of the President. Then, the judge so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court in priority to other duties of his office. Yes, while so attending, he enjoys all the jurisdiction, powers and privileges of a judge of the Supreme Court. Yes, this is the ad hoc judge. Then retired judges. So at any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as a judge of Supreme Court for a temporary period. Yes, he can do so only with the previous consent of the President and also of the person to be so appointed. Yes, such a judge is entitled to such allowances as the President may determine. Yes, he will also enjoy the jurisdiction, powers and privileges of a judge of the Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. Now, procedure of court. Yes, now we'll see the procedure of court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. Yes, the constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. So all other cases are usually decided by a bench consisting of not less than 3 judges. Yes. So the judgment are delivered by the open court. Yes. And all judgments are by majority vote, but if differing, the judges can give dissenting judgment or opinions. Yes, the constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. Now, the supreme independence of Supreme Court. Yes. So, the Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizen and guardian of the Constitution. Yes. So, therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. Yes, it should be free from the encroachments, pressures, and interference of the executive, that is Council of Ministers, and the legislature, that is Parliament. It should be allowed to justice without fear or favor. Yes. So the independence of the Supreme Court. So the Constitution has made following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. Yes. The judges of the Supreme Court are appointed by the President in consultation with the members of the judiciary itself. Yes. So the mode of appointment. Now we'll see the provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court were first mode of appointment. Correction. Mode of appointment. Yes, the judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, that is judges of the Supreme Court and the High Courts. This provision curtails the absolute discretion of the executive as well as ensure that the judicial appointments are not based on any political or practical considerations. Then second, security of tenure. Yes, the judges of the Supreme Court are provided with the security of tenure. Yes, they can be removed from office by the President only in the manner or on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President or though they are appointed by him. So this is obvious from the fact that no judge of Supreme Court has been removed or impeached so far. Yes, then fixed service conditions. So the salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during financial emergency. Yes, thus the condition of service of the judges of the Supreme Court remains same during their term of office. Yes. Then expenses charged on consolidated fund. Yes, the salaries, allowances and pensions of the judges and the staff as well as all the administrative expenses of the Supreme Court are charged on the Consolidated Fund of India. Yes, thus they are non-votable by the Parliament, through they can be discussed by it. Yes, expenses charged on Consolidated Fund. Then conduct of judges cannot be discussed. Yes, the Constitution prohibits any discussion in Parliament or in state legislature with respect to the conduct of judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. Yes, ban on practice after retirement. So the retired judges of the Supreme Court are prohibited from pleasing or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of a future or favor then power to punish for its contempt. The Supreme Court can punish any person for its contempt, thus, its actions and decisions cannot be criticized and opposed by anybody. Yes, this power is vested in the Supreme Court to maintain its authority, dignity, and honor. Yes, then freedom to appoint its staff. So, the Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive, and he can also prescribe their conditions of service. Then its jurisdiction cannot be curtailed. So the Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court, and the Constitution has guaranteed to the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. Yes. Then the provision of separation from executive. The Constitution directs that the state to take steps to separate the judiciary from the executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of the executive authorities in judicial administration came to an end. Yes, the Criminal Procedure Code 1973 has effected the separation of judiciary from the executive. Yes, Article 50 under the directive principles of state policy. Now we'll see the jurisdiction and powers of Supreme Court. Yes, the Constitution has conferred a very extensive jurisdiction and vast powers on the Supreme Court. Yes. So the jurisdiction and powers of the Supreme Court can be classified into original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction, a court on record, power of judicial review, constitutional interpretation, and other powers. Yes. Now, original jurisdiction. So, as a federal court, the Supreme Court decides disputes between different units of the Indian Federation. So, more elaborately, any dispute between the center and one or more states, the center and any state or states on one side, and one or more states on the other, and between two or more states. Yes, the original jurisdiction. As a federal court, the Supreme Court decides dispute between different units of the Indian Federation. Yes. So in above federal disputes, the Supreme Court has exclusively original jurisdiction. Yes. Further, this jurisdiction of the Supreme Court does not extend it to the following, like a dispute arising out of any pre-constitution treaty, agreement, covenant, yes, engagement, sanad, or other similar instrument. Yes. A dispute arising out of any treaty, agreement, etc., which especially provides that the said jurisdiction does not extend to such a dispute. Interstate water disputes, matters referred to the Finance Commission, adjustment of certain expenses and pensions between the center and the states, ordinary dispute of commercial nature between the center and the states, recovery of damages by a state against the center. Yes. After that, writ jurisdiction. So the Supreme Court is empowered the Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto and certiorari. Yes, certiorari. So for the enforcement of the fundamental rights of an aggrieved citizen, yes, in this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can go directly to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. So the High Courts are also empowered to issue writs for the enforcement of the fundamental rights. Yes, then appellate jurisdiction. Appellate jurisdiction, the Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under four heads: appeals in constitutional matters, appeals in civil matters, appeals in criminal matters, appeals by special leave. Yes, then advisory jurisdiction. The Constitution under Article 143 authorizes the President to seek the opinion of the Supreme Court in two categories of matters, like on any question of law or fact of public importance which has arisen or which is likely to arise, any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sandor or the similar instruments. Yes. Then a court of record. Yes. So, the court of record. As a court of record, the Supreme Court has two powers: the judgments, proceedings, and acts of Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of even evidentiary value and cannot be questioned when produced before any court. Yes, they are recognized as legal precedents, and legal references. It has power to punish for contempt of court, either with simple imprisonment for a term up to 6 months or with fine up to 2000 or with both? Yes. Then power of judicial review. Yes, judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. So, on examination, if they are found to be violative of the constitution, that is ultra vires, they can be declared as illegal, unconstitutional, and invalid, that is null and void, by the Supreme Court. So, consequently, they cannot be enforced by the government. Now, constitutional interpretation. Yes, the Supreme Court is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. Yes, while interpreting the Constitution, the Supreme Court is guided by a number of doctrines. In other words, the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are mentioned below, like doctrine of severability, doctrine of waiver, doctrine of eclipse, doctrine of territorial nexus, doctrine of pith and substance, doctrine of colorable legislation, doctrine of implied powers, doctrine of incidental and ancillary powers, doctrine of precedent, doctrine of occupied field, doctrine of prospective overruling, doctrine of harmonious construction, and doctrine of liberal interpretation. Yes, these are the constitutional interpretation, and the Supreme Court applies various doctrines in interpreting the Constitution. Now we'll see the other powers is the feature which empowering to work independently. Yes, as a judicial system. So the Supreme Court has numerous other powers, like it decides the disputes regarding the election of the president and the vice president. In this regard, it has the original, exclusive, and final authority. Then it inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission on a reference made by the president. If it find them guilty of misbehavior, yes, it can be recommended to the president for their removal. Yes, the advice tendered by the Supreme Court in this regard is binding on the president. Yes, it has power to review its own judgment or order. Thus, it is not bound by its previous decision and can depart from it in the interest of the justice or community welfare. In brief, the Supreme Court is a self-correcting agency. For example, in the Keshwananda Bharati case 1973, the Supreme Court departed from its previous judgment. In the Golaknath case 1967, yes, Pragati, good evening. We are studying today all the information regarding Supreme Court of India. Yes, and Now we are seeing the provisions for the independence work of the Supreme Court. Yes, it is authorized to withdraw the cases pending before the high courts and dispose them by itself. It can also transfer a case or appeal pending before one high court to another high court. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. Yes, all all authorities, that is civil and judicial, in the country should act in aid of the Supreme Court. Yes, it has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. Yes, the Supreme Court jurisdiction and powers with respect to matters in the union list can be enlarged by a parliament. So further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the center and the state. Yes, Supreme Court advocates. Yes, three categories of advocates are entitled to practice law before the Supreme Court. Yes, first, senior advocates. So, these are advocates who are designated as senior advocates by the Supreme Court of India or by any high court. The court can designate any advocate with his consent as senior advocate if in its opinion by virtue of his ability, standing at the bar or special knowledge or experience in law, the said advocate is deserving of a such distinction. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instructions to draw pleadings or affidavits, advice on evidence, or do any drafting work and analogous kind in any court or tribunal in India or undertake convincing work of any kind whatsoever, but this prohibition shall not be extended to settling any such matter as aforesaid in consultation with a junior, yes, a senior advocate. Then advocates on record. Yes, second category, advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. Then other advocates. These are advocates whose name are entered on the roll of any state bar council maintained under Advocates Act 1961, and they can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. Yes. So these are the three categories of advocates: senior advocates, advocates on record, and other advocates. Yes. Now after that, we'll see recent issues in Supreme Court. Yes. Now, Master of roster. Yes, it refers to the privilege of Chief Justice to constitute benches to hear cases. The controversy has emerged in the Supreme Court over absolute power of Chief Justice on the judicial administration. Yes, the Supreme Court has upheld a number of times that the Chief Justice is the master of the roster and he alone has the prerogative to constitute the benches of the court and allocate cases to the benches so constituted. Yes, be it the Chief Justice of India or Chief Justice of any High Court, it is he or she who heads the administrative side, and this includes allocation of matters before judges as well. So, no judge can take up the matter on his own unless allocated by the Chief Justice of India. Yes, Master of Roster. Now, we'll see the latest updates related with the Supreme Court of India. Yes, recently, former Supreme Court Judge Justice P.B. Sawant passed away on 15th February 2021. Yes, Supreme Court is next. Supreme Court examining a petition relating to the social media firm Facebook and its messaging application WhatsApp over the terms of service and privacy policy that were to be out on February 8, 2021. And statement from Supreme Court while dismissing a review petition on the anti-citizenship law protest held in Delhi's Shaheen Bagh in 2019. So right to protest cannot be anytime, everywhere. Yes, this was the statement on 13 February 2021. Yes, so these are the latest updates related with the Constitution of India. Correction. These are the latest update of the Supreme Court of India. Now, after that, we'll see the articles related to Supreme Court of India at a glance. Yes, Article 124, Establishment and Constitution of Supreme Court. Article 124 deals with the establishment and constitution of Supreme Court. Then Article 124A, National Judicial Appointments Commission. Article 124B, Functions of Commission. Article 124C, Power of Parliament to make law. Article 125, Salaries of judges. Article 126, Appointment of Acting Chief Justice. Article 127, Appointment of ad hoc judges. Article 128, Attendance of retired judges at sittings of the Supreme Court. Article 129, Supreme Court to be a court of record. Article 138, Seat of Supreme Court. Article 131, Original jurisdiction of the Supreme Court. Article 131A, this article was repealed. Article 132, Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. Article 133, Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. Then Article 134, Appellate jurisdiction of Supreme Court in regard to criminal matters. Article 134A, certificate for appeal to the Supreme Court. Then Article 135, jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court. Article 136, special leave to appeal by the Supreme Court. Article 137, review of judgments or orders by the Supreme Court. Article 138, enlargement of the jurisdiction of the Supreme Court. Article 139, conferment on the Supreme Court of powers to issue certain writs. Article 139A, transfer of certain cases. Article 140, ancillary powers of Supreme Court. Then Article 141, Article 141, which law declared by Supreme Court to be binding on all courts. Article 142, enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. Article 143, power of President to consult Supreme Court. Article 144, civil and judicial authorities to act in aid of the Supreme Court. Article 144A, special provisions as to disposal of questions relating to constitutional validity of laws. This Article 144A was repealed. Article 145, rules of courts. Article 146, officers and servants of and the expenses of the Supreme Court. Article 147, that is interpretation. Yes, friends. So, this is about the articles related to the Supreme Court. Yes, that is Article 124 to Article 147. So friends, that's it for today's session. Just have a recap what we have covered in today's session. Yes. Friends, do not forget to enroll yourself for Unacademy free test series. Just you have to use code RBI Live to unlock the test. Then these are the new batches. Then Unacademy Combat we are conducting on every Sunday in the morning 11 o'clock. Yes, we have covered complete Supreme Court and its all information in this session. Yes, the apex judicial court or Supreme Court as at the top. We have integrated judicial system in India where Supreme Court at the top, High Court at the state level, and then low court and subordinate courts at the lower level. Yes. Article 124 to 147 in part 5 of the Constitution deal with the Supreme Court. Then we have covered brief history. Yes. Then constitutional provisions, composition and appointment of judges, collegium system, working of collegium system and NJAC, National Judicial Commission Act, controversy over consultation and evolution of collegium system, qualification, oath and salaries, oath and affirmation, salaries and allowances, Then we have covered tenure of judges, removal of judges. Then we have covered the Chief Justices of India, the present Chief Justice of India, Honorable Mr. Justice Sharad Arvind Bobde. Then we have covered former Honorable Chief Justice of India, yes. Then we have covered acting, ad hoc and retired judges. Then procedure of court. Then we have covered the important part, that is independence of Supreme Court. Yes, so how Supreme Court is guarantor of the fundamental rights of the citizen and guardian of the Constitution. Yes, so we have covered the provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court, mode of appointment, security of tenure, fixed service conditions, expenses charged on consolidated fund, conduct of judges cannot be discussed in parliament or in state legislature. Then ban on practice after retirement, power to punish for its contempt, freedom to appoint its staff, its jurisdiction cannot be curtailed, and separation from executive. Then jurisdiction and powers of Supreme Court, where we have covered original jurisdiction, read jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record, power of judicial review, constitutional interpretation, and other powers. Yes, it's all about the original jurisdiction. So the Supreme Court has exclusive original jurisdiction. Then we have covered exceptions up to that: read jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record, then power of judicial review, constitutional interpretation, other powers. Then types of advocates, that is categories. It's not types, the three categories of advocates of Supreme Court: senior advocates, advocates on record, and other advocates. Then we have covered recent issues and latest updates relating with the Supreme Court of India. Yes. Then we have covered the articles related with the Supreme Court of India at a glance, from Article 124 to Article 147. Yes. So that's it for today's session. Friends, see you in the next lecture with new topic of Indian polity. Till the time, keep studying, keep revising. Do not forget to join our Telegram group, and also you can use my referral code RBI Live to get 10% discount on your paid courses. Please like, share, and subscribe Unacademy videos. Take care. Thank you.